Welcome back to everyone. In this fifth lesson, we're going to deal with one of the core concepts of the constitutional dimension of the European Union legal order, namely the European citizenship. First of all, we have to give a definition of citizenship. In order to be able to define it, we should understand whether this concept is related to the idea of nation or state. Indeed, a nation is a group of people with a common language, history, culture, and, let's say, usually, geographic territory. A state is an association of people characterized by formal institutions of government, including laws, permanent territorial boundaries, and sovereignty. That is to say, political independence. According to these definitions, the citizenship seems to be linked to the concept of state. Indeed, each state can determine the conditions under which it will recognize persons as its citizens. Consequently, does the definition of citizenship depend on the concept of citizen? The answer is yes. But what is a citizen? A citizen is a member of a political community who enjoys the rights and assumes the duties of a membership. This broad definition is discernible with minor variations in the works of contemporary authors as well as the entry citoyen in the Diderot's and d'Alembert's Encyclopédie in 1753. The encyclopedist's main preoccupation, understandable for one living in a monarchy, was the relationship between the concepts citizen and person who is subject to the monarch. Were they the same, as Hobbes asserted, or different, as a reading of Aristotle suggested? This issue is less central today, as we tend to take for granted that a liberal democratic regime is the appropriate starting point for our reflections. As we have already said, each state determines the conditions under which it will recognize persons as its citizens, but also the conditions under which that status will be withdrawn. Recognition by a state as a citizen generally carries with it recognition of civil, political, and social rights which are not offered to non-citizens. In general, the basic rights normally regarded as arising from citizenship are the right to a passport, the right to leave and return to the country of citizenship, the right to live in that country, and to work there. Our concept of citizenship is evolving. Modern thinking requires that one should no longer be geographically constrained by bloodline or place of birth. Nowadays, there are three forms by which one may be granted citizenship of a particular country. Jus sanguinis, that is to say, citizenship by bloodline. Jus soli, that is to say, citizenship by birth. And jus doni, that means citizenship by investment. The most common out of these three is, with no doubt, jus sanguinis, or citizenship by bloodline. This form grants citizenship right based on one's parents being nationals of a particular state. This fact enables you to claim citizenship of a particular country based on the nationality of your parents. In addition to being the most common form of citizenship, it is also the simplest. Jus soli, or citizenship by birth, is another form of citizenship acquisition whereby one is granted citizenship based on their country of birth. While one may imagine this to be a fairly common form of citizenship, there is no European country that will grant citizenship on this basis alone. There are certain factors that must be met for you solely to become an individual's sole option for being granted citizenship, such as parents being from a specific country, as well as various naturalization requirements, as for instance, the knowledge of local language. Lastly, there is jus doni, or citizenship by investment. This is a process whereby individuals can become citizens of a particular state by meeting certain specific requirements, usually making an approved investment into the economy, the nation, and meeting certain residency requirements. For the sake of completeness, we should also know that there are two dimensions of citizenship, a legal and a political one. The first one is citizenship as legal status, defined by civil, political, and social rights. Here, the citizen is the legal person free to act according to the law and having the right to claim the law's protection. It doesn't mean that the citizen takes part in the law's formulation, nor does it require that rights be uniform between citizens. The second dimension considers citizens specifically as political agents actively participating in a society's political institutions. In order to better understand the distinction between the two dimensions, we only need to think about the difference between the concept of citizenship in ancient Greece and that in ancient Rome. Indeed, in ancient Greece, the first democratic political system was developed, and a fundamental role was assigned to civic participation. Citizens were political subjects who, as such, could participate in the democratic process of normative production. This is the political dimension. By contrast, in the Roman world, the individual was legally recognized as a legal subject, thus the legal dimension, as the holder of rights and duties before the state. Nowadays, the European Union citizenship is a mix of both the two dimensions. Indeed, having seen the evolution of the concept of citizenship, one must now understand whether or not this definition also corresponds to that of European citizenship. The concept of European Union citizenship dates back to the Maastricht Treaty. In fact, the Treaty on European Union, the Maastricht Treaty, first introduced the legal concept of citizenship into European Union law. Although this represented the first formal introduction of European Union citizenship, the idea of community citizenship and the concept of a people's Europe had been in circulation for a long time. The introduction of European Union citizenship was greeted at the time thanks to the help given by the European Court of Justice that said, Union citizenship is destined to be the fundamental status of nationals of the member states. Therefore, we might say that the European Union citizenship is the last achievement that we have reached as people of Europe. The European Union aims to allow its citizens to study, work, and stay in any European Union country and to sell or buy products in all of Europe. To this end, it guarantees the free movement of people, goods, services, and capital in a single internal market at the European Union level. Today, Europe guarantees its citizens the freedom to move, reside, and settle in any European Union member state, with rights equal to the residents of that state. It is not therefore a mere touristic freedom. This right has been strengthened by the Schengen Agreement. This agreement, concluded in 1985, provides for the abolition of border controls among the signatory countries. The Schengen Agreement, in order to ensure greater security for European Union citizens, also provides for cooperation among the police forces of participating member states through an information system called Schengen Information System. The Schengen Information System allows to report suspicious people and traffic and is based on mutual legal assistance and anti-drug collaboration. The freedom of movement for services allows European citizens, notably the workers, to move to another state of the Union and to work and provide their services there, getting the same treatment as the workers of that member state. In this perspective, the European Union prohibits individual member states from imposing residence restrictions or any other discrimination in the workplace. Equal treatment is therefore ensured for all citizens of the European Union in the selection and hiring of personnel, in working conditions, in wage levels, in assistance, and in social security. To facilitate the freedom to settlement and the freedom to provide services, every European citizen has the right to request the recognition of diplomas and qualifications issued at national level. Apart from the new and potentially very important rights introduced by the Treaty on European Union, is the idea and the concept of European Union citizenship able to supplement and strengthen all the existing treaty-based rights of workers, job seekers, and students? In order to understand the real meaning of this concept, and so to answer to the latter question, we should start by analyzing the treaties of European Union, providing the useful elements of European Union citizenship. Namely, we should start with the articles of the Treaty on European Union and then continue with those of the Treaty on the Functioning of European Union. According to Article 9, Paragraph 2 of the Treaty on European Union, every national of a member state shall be a citizen of the Union. Citizenship of the Union shall be additional to and not replace national citizenship. This article provides the foundation of European Union citizenship in the EU. As regards the latter, it shows that in light of a lack of a single European people, the European Union's citizens are the central pillar of democracy in the EU. It is expression of a fundamental value of the European Union, notably the principle of democracy that is also provided for in the European Charter of Fundamental Rights, the Nice Charter. It confines equal treatment to all European Union citizens. Article 10 of the Treaty on European Union specifies this right by stating that citizens are directly represented at the Union level in the European Parliament. Every citizen shall have the right to participate in the democratic life of the Union. Decisions shall be taken as openly as closely as possible to the citizen. We have to think Europe as the ancient Greeks, because Europe is close to its people as the polis used to be to their citizens. Indeed, Article 10 of the Treaty on European Union gives substance to the principle of democracy in the European Union legal order, which is, let's say, the principle of democracy, one of its founding principles. This article reveals that the European Union is fundamentally a representative democracy based on the equality of all citizens. This means that every single European Union citizen must be represented in the European Parliament. Article 10, this provision, aims to strengthen the legitimacy of Union decision making. The fundamental choice of representative democracy as the European Union's model implies that, as a rule, decisions are taken by the people's representatives rather than directly by the people themselves. And this is the difference between EU democracy and the direct system of police democracy. Elements of participatory democracy can be found throughout the treaties. The most important ones are the European Citizens' Initiative. We will see it later. The right to petition to European Parliament, the right to complain to the European Ombudsman, the Commission's dialogue with representative association and civil society. Nevertheless, we don't have to forget that these elements of participatory democracy at the Union level are supplemented by opportunities for citizens to participate at the national level with rights to petition national parliaments and governments, as well as the increasing likelihood of referendums on specific EU-related questions. At last, but not at least, we have to talk about transparency and proximity to the citizen. Transparent decision-making enables citizens to participate more closely in the decision-making process and guarantees that the administration enjoys greater legitimacy. Certain degree of transparency is thus an indispensable element of every democracy. Closely connected to this is the objective that decisions are taken as closely as possible to the EU citizen. It is suggested that such decisions tend to be viewed as more legitimate. This demonstrates a link to the role of national parliaments in overseeing its correct implementation. Thank you for your kind attention.